can. So with that background, I'll call the first case on the docket this afternoon. It is from right here in Sedgwick County. It's number 127682, entitled Kedrin, Littlejohn versus the State of Kansas. We have Mr. Maloney for the appellant, the State of Kansas. And is it Mr. David Miller?
It is, Your Honor.
For the appellee. Mr. Maloney, you will begin, and do you wish to reserve any time for rebuttal?
Yes, Your Honor. I'd like to reserve 3 minutes, please.
That is granted.
Thank you, Your Honor. Your Honors, it was just over 17 years ago that the victim, Mr. Collins, was killed in a brutal manner in downtown Wichita in the middle of broad daylight. That conviction has been upheld by our Supreme Court, but now we are in a position where the district court has ordered a new trial after a 1507 hearing, after determining that trial counsel, now Judge Pittman, was ineffective. In the brief, I listed numerous problems with the district court's ruling, and I do plan to address those today, as many as possible. But I want to start by highlighting what I think is far and away the most critical mistake that the district court made. And that is quite simply that the district court's ruling ignored decades worth of precedents from our Supreme Court with respect to handling ineffective assistance of counsel claims. We have hundreds of cases that tell us the standard for that. But I want to start by reading 2 brief quotes that I have on the bottom of page 19 of my brief, because this really gets to the heart of what the district court did wrong here. In State v. Hutto, a 2021 case, the Supreme Court reiterated that strategic choices that counsel make after thoroughly investigating the law and facts relevant to plausible options are virtually unchallengeable. And in State v. Flynn, a 2006 case, the court said that even though experienced attorneys might disagree on the best tactics or strategy, deliberate decisions based on strategy may not establish ineffective assistance of counsel. In this case, Judge Pittman testified at length at the evidentiary hearing, and he identified not one strategic reason, but numerous reasons why he chose not to pursue a mental disease or defect defense. Some of those were factual. He reviewed the facts with his client. He observed his client's demeanor in their meetings and found no basis to believe that he did have a mental disease or defect. He also identified strategic reasons, such as the fact that from experience, having used this defense before, he found that it generally was not successful or well received by jurors. He also felt that it would be contradictory and to some extent to the defense that they did run, which was a compulsion defense. He was also concerned about trying to portray the defendant as a victim in the case. But importantly, not only did he identify strategic reasons, he very clearly testified that he did consider this defense. It wasn't something that he simply overlooked. He considered it by reviewing the report from Dr. Fletcher. He spoke with Dr. Fletcher about that report. He spoke with his client's moms countless times, was the language that he used at the evidentiary hearing. He met with his client. He reviewed the facts and the evidence with his client and found absolutely no basis to think that it was a viable defense. He testified that in meeting his client, he was struck by how different he appeared than in some of the descriptions from his mother or even from some of the reports that the defense purported to rely on. Judge Pittman had also appeared on the defendant's behalf and was representing him at the suppression hearing and at the competency phase. And I think it's especially notable that in denying the suppression motion, the district court actually indicated that Dr. Fletcher's report was more harmful than beneficial to the defense. I think the court used the language, especially in light of Dr. Fletcher's report, it had no basis to conclude that the statement was involuntary.
Now, this case is a little different than most, where we have counsel's
testimony which you've aptly summarized, because there's testimony to the contrary, that in fact it was not a strategic decision at all. So are you asking us to reweigh the facts?
I don't think there was testimony that it wasn't strategic. There was testimony from the defense witnesses that they disagreed.
Well, didn't Loeffler testify that he would have used the defense, or she, was it he?
He, yes.
He would have used the defense.
Yes.
And he said, and it was not strategic.
I don't remember that specific part of Loeffler's testimony. I also don't know how he would purport to know. I certainly can understand that one attorney might disagree with a decision from another attorney. I don't know how he would purport to get inside Judge Pittman's mind and know whether it was a strategic decision. But I think most importantly, the district court did not find that Mr. Pittman's testimony was not credible. And I do want to emphasize that today because it's very important. And I know that oftentimes as the appellee, in most cases, the state will certainly point to credibility findings and how they are virtually unchallengeable. We're not asking the court to reweigh any credibility findings because, quite frankly, there were not credibility findings in this ruling. The court never said that it didn't believe testimony from Mr. Pittman when he testified about why he did or did not do things. It didn't find that he was not credible in explaining his investigation or his strategic reasons. I think at one point the court even said that some of the reasons that Mr. Pittman provided at the hearing might well have been well-founded. And yet, despite that, the court somehow ignored decades worth of precedents and found that it was ineffective assistance of counsel not to use this defense, even though...
Did the court thus impliedly find it was not a strategic decision?
I don't think so when you read that ruling. I really don't. And I would especially point the analysis that the court engaged in on the prejudice prong was slim, to put it charitably. Essentially, with respect to the performance prong, the court simply recited things that counsel could have done or how it might have benefited the defendant if the jury had heard certain testimony or evidence, but then did little to no analysis of the prejudice prong. It essentially just restated the test and said, and I find that prejudice prong is met. So I don't think this is a case where there really are any either express or implied credibility findings. I think that this was simply a court that misunderstood the law with respect to what a defendant has to show.
Strategic decisions are virtually unchallengeable if they're based on thorough investigation. Isn't that really the dispute here? The judge found there wasn't sufficient investigation, and there were disputed facts on that.
Yeah, I don't know. Again, he never once found that Pittman did not take any of the steps that he said he took. And I just want to reiterate here to summarize, these are all of the things that Judge Pittman did to investigate this potential defense. He talked to his client's mom countless times. He met with Dr. Fletcher. He reviewed Fletcher's report. He reviewed a report from another doctor, Dr. Parrish. He reviewed the evidence with his client, and more broadly, he simply met with his client and observed his demeanor, and that led him to believe that he simply was not, that it wasn't a viable defense.
One of the things that counsel said was he just didn't think that that defense is generally going to be successful, and I tend to agree with that. I'm not sure if I've ever seen a standalone mental deficiency defense to be a winning defense. But what impresses me about this case is the defense they did use was compulsion. And I don't understand how defense counsel tried to sell that to the jury without the evidence of the 70 IQ that the defendant had in this case.
Right. Well, I think he did address that directly, and he said that in his mind he felt that it would actually be somewhat contradictory because he felt like in order to show that, in essence, he felt like if you were trying to argue on the one hand that his client had this limited IQ and didn't understand what was happening and couldn't make rational decisions, that it would then be contradictory to try to point to the fact that, oh, but yet he understood that his co-defendant was somehow coercing him. And again, I would say that is a strategic, it's something that certainly another attorney might look at and view differently. I think reasonable attorneys could come to different conclusions on which approach that they would take. But again, he did have a specific strategic reason for making that decision, and he had reviewed all of the information available. And I think also, with respect to the IQ issue, it is important to note that's the only thing we're talking about here. There's no allegation that he had some sort of mental disease or that he was schizophrenic or he had other mental issues. It was simply focused on the IQ. And there are a couple of important parts about that. First of all, the IQ score was slightly above the threshold for what would generally be considered the cutoff point. And Dr. Fletcher acknowledged that. He also acknowledged that when you broke his results down by the different subcategories of IQ testing, that his results actually were such that you would have to be even more leery of them because he scored higher in certain parts of the test that would be relevant in assessing whether he was in fact able to form intent.
But other tests showed him to have a 49 IQ, correct?
Right, but I think even the defense expert at the hearing indicated that those tests, that test was an outlier, and the defense was relying on this score of 71. And the expert that they presented, Dr. Hutchison, at the hearing even said that, yeah, she thought that the 71 test was the most accurate reflection. And her testimony, I would argue, is of limited value because she acknowledged that there were numerous facts that she was unaware of. She had not conducted an independent evaluation. She knew very little about the facts of the case. And those facts are critical here because when you look at whether Mr. Pittman was ineffective for making a choice not to use that defense, our facts here show that after the crime, the defendant returned to the scene, apparently ostensibly to get his phone because he was worried it had been left behind. He then gave a false name to a police officer at the scene. He fabricated a story about his phone being stolen by the occupants of the Hummer. When he was then taken downtown for questioning, he faked a medical issue to try and stall the process. He then repeated that false story. It was only after he was presented with some damning evidence that he changed his story, and at that point gave a full recitation of not only the crime, but what led up to it, and very clearly indicated that he was involved in the planning. This was not something where he was just being dragged along by his co-defendant. He then faked another medical issue, and then, after the interview, he speculated to one of the officers that he would end up spending the rest of his life in jail. Now, I ask this court, how are any of those actions consistent with somebody whose IQ is so low or his intellectual capacity is so impaired that he was not able to form intent? And that's what the mental disease and defect defense is. You have to show that you are incapable of forming the required intent. And all of the evidence shows otherwise in this case.
Let me ask you, regardless of the assertion of that defense, did the jury have any evidence as to his IQ or school records or psych evals?
I off the top of my head, I cannot recall. I'm sure counsel will be able to probably answer that question, and I don't want to answer wrong on that. I can't remember if that was ever specifically put into evidence in this case. Off the top of my head, I'm not sure how it would have necessarily come in since the defense did not pursue this theory. But they certainly knew the facts of the case, and they were able to evaluate that. And I know one of the cases that the defense relies on heavily in this case, and in many cases that we see, is Mullins versus State. And I pointed out on page 33, there are so many ways that this case is distinguished. In Mullins, you had an attorney who was very inexperienced, had no experience trying sexual assault cases. That attorney had testified that he or she did not even consider hiring an expert on the relevant topic. And then counsel at the post-conviction hearing stage, counsel testified that he should have hired an expert. In this case, we have a very experienced attorney, not only in general, but in trying serious cases, and an attorney who had experience using the mental disease and defect approach. And that was part of the reason why he had personal experience knowing that it generally was not a successful, well-received defense. We also clearly don't have an attorney who got up and said, yeah, I should have done this. Quite to the contrary, Mr. Pittman explained, again, he didn't give one or two strategic reasons. He gave a whole list of reasons, and that list, again, was something that he arrived at after thoroughly investigating the facts of the case and of his client's mental state. There's no assertion that he was unaware of any of the reports regarding his client's IQ. There's no assertion that he didn't know the facts of the case. There's no assertion that he didn't meet with his client. There's no assertion that he didn't listen to the defendant's mother talk about her concerns for his intellectual capacity. In fact, that actually put him on heightened alert for it. That's why he was careful to look for signs of it when he was actually meeting with his client. And again, he explained to the court that when he actually met with his client in person, he was struck by how different he was than what he had been led to believe. And of course, if he's running this defense, the jury is going to see the same thing. They're going to see the defendant in person as well. So in sum, again, I pointed out a lot of the specific issues. I think that the most glaring factual finding that I think is completely contrary to the evidence, not supported by sufficient evidence, is the finding that he did not fully investigate this defense for all of the reasons that I've already set forth. But when you boil it down, the main reason that the state feels in this case that the district court erred is that it simply misapplied that test. If a case like this can be remanded for a new trial, then I would posit that there's never going to be a conviction that gets any finality, because there's never going to be a case where every single attorney would have handled it exactly the same way. And so while I certainly understand that there's nothing wrong with the defense presenting the testimony of Mr. Loeffler and Ms. Zygtema, that testimony is of limited value when all they're essentially doing is saying that they would have done it differently. And as I note in the brief, Ms. Zygtema acknowledged she's never met the defendant and she had only had limited interaction with him via phone and email. And Mr. Loeffler, while he said in hindsight that he would have run this defense, it's noteworthy that while he was the attorney on the case, he never filed notice of his intent to do so. And the statute requires that to be done within 30 days of arraignment. And so while he, 15 years after the case, after the fact, got up and testified that he would have done it, I think the record casts some doubt on that. But more to the point, even if you do credit that testimony and think that he would have chosen a different path, that's the exact type of thing that does not lead to a successful ineffective assistance of counsel claim.
You're moving into your rebuttal time.
Sure, I figured that was the case, Your Honor, and I would reserve the rest of my time for rebuttal.
May it please the court, David Miller for Mr. Littlejohn. I wanted to go right to a question that was asked and point the court to Volume 1, page 174 to 175 of the Record on Appeal. There, the Judge Ward, who has been a trial judge for many, many, many years in the state, says, considering all the circumstances, including the record of the 1507, everything that was reviewed, the court concludes that trial counsel Pittman's failure to fully investigate and present a mental disease defect defense in this case fell below an objective standard of reasonably effective representation. Pittman's conclusion that mental disease defect was not applicable was a faulty legal assessment, inconsistent with prevailing professional norms, and he cited the case of Shumway versus State. The state wants to cast this as the judge just accepted, or the judge substituted Kevin Loeffler, Kate Zygtema, Dr. Flesher, who aside from being a psychologist, is also a licensed attorney, just simply substituted their version or their testimony for that of Judge Pittman. And that's not the case at all.
Wasn't a significant piece in this case was that Pittman never even discussed the possible defense with Flesher, or am I remembering that wrong?
That is absolutely correct, Your Honor. And I wanted to also point out, Dr. Flesher, his report was limited to the Miranda issue, whether Mr. Littlejohn could effectively understand the Miranda warnings and whether he could waive those warnings. And that was the sole purpose of that report. He came to the conclusion that he would need very strong help and assistance in order to even understand Miranda and waive it. So Judge Pittman, and he testified to this, he said, I may have talked a little bit with Dr. Fletcher, but never went into any in-depth specifically on the disease of mental disease and defect. He also clearly testified, I never consulted any other expert or hired any other expert to inquire specifically as to the viability of the mental disease and defect defense. And so I know the state has argued that this was a strategic decision. And I think, Judge Malone, you pointed out the rub here, as Flores-Ortega, the U.S. Supreme Court case says, it's not simply whether a decision is strategic, it's whether a decision is reasonable under all the circumstances. Now, the state has cited to strategic decisions, or that this was a strategic decision based upon, by my count, about 4 different reasons. One, Judge Pittman's interaction with the petitioner. And I know that there was an assertion that there wasn't really any conflict in the evidence regarding that, when in fact there was. I introduced at the hearing the jail records, which demonstrated that Judge Pittman met with Mr. Littlejohn twice before trial for a total of 73 minutes. And I did cite, it's an unpublished opinion, where in that case, I believe it was also a murder case where the defense attorney met a couple, maybe 2 to 3 hours, and the court, and this court in that case indicated that due to the severity of the charges that was certainly not sufficient time. Here, 73 minutes interaction between Mr. Littlejohn and Judge Pittman. The second is that he talked to Mr. Littlejohn's mother. That's true, he did. But I don't really understand how that's a strategic decision, because Mr. Littlejohn's mother said, he's got intellectual deficiencies. I'm concerned about whether he even understood what was going on in this case. She gave him Dr. Parrish's report from 2006 when he was 17 years of age, where it was reported a 49 IQ. I understand Dr. Hutchison, who I called at the evidentiary hearing, thought that was somewhat of an outlier, but she thought certainly in the range between 60 and 70 IQ. But nevertheless, what is consistent from Dr. Parrish to Dr. Flesher and to Dr. Hutchison is consistently Mr. Littlejohn is reading at the 2nd grade level, arithmetic at the 3rd grade level, and that doesn't change from the time he was, he was diagnosed with a learning disability when he was, I don't want to misrepresent the record, I think when he was 8, all the way up through, of course, the Dr. Flesher's report and then the ComCare report, which also noted significant intellectual disabilities. Another is the conflict in running both defenses. And in fact, there is no conflict. And Judge Pittman actually testified to that. I asked him about the compulsion defense, and there is a component of the compulsion defense that talks about, would a person reasonably fear death or great bodily harm under the circumstances. There's also in the subpart of the compulsion defense whether a person wantonly or willfully put themselves in that situation. Judge Pittman agreed with me, at least to the second part, that mental capacity would have directly gone to those issues. And to answer another question of the court, now that I'm thinking about it, and this is noted in the Court of Appeals decisions before this, there was no evidence of Mr. Littlejohn's IQ, no evidence of his mental capacity that the jury ever heard in this case. And Judge Pittman acknowledged that that kind of evidence went directly to the compulsion defense. Now, what he said is, I had a layperson, Carla Abrahamson, the mother of Mr. Littlejohn, come in and testify about his mental capacity. I addressed this in the brief. I cite the record on appeal to Ms. Abrahamson's testimony. There's no testimony, zero testimony about his mental capacity. So not even in support of his own defense, that is compulsion defense, was there any evidence of his mental capacity that was introduced. I understand also the fourth is Judge Pittman apparently had a dislike of the defense. In other words, a standalone defense. But again, as I argued and as I'm arguing here today, the compulsion and the mental defense are not antagonistic to one another. They go together. And in fact, Judge Ward, Volume 1, page 175, even made a factual finding that that is Judge Pittman's distrust of that mental disease or defect defense, the judge found led him to not doing a reasonable investigation of this defense and or how that defense fits into the compulsion defense. While I'm on the subject, the state did not brief. The only issue that the state briefed in this case is the mental disease or defect, the failure to put on the mental disease or defect. But Judge Ward's ruling below rests on two bases. One, the mental disease or defect defense, the failure to investigate and put it on, but also the failure to put on mental capacity defense in support of his own defense. And the state did not brief that issue before the court in this appeal. My view, and as I've argued, the purpose that I called Kevin Loeffler, the purpose I called Kate Zygtema and Mitchell Flesher in part was to demonstrate a standard. And that has been, Mullins is a prime example of calling an attorney to set the reasonable standard. Mullins did it. I did cite Spangler decision. It's an unpublished decision. It's 120-137. And there it said the district court relied very heavily on the attorney who came in and testified about setting that standard of reasonable, the objective standard of reasonableness. And in that case, it was a failure to call a mental health expert or do any sort of an investigation or a substandard investigation. Chamberlain also, I cited, the courts do look to what is the prevailing norm in the community. And Judge Ward, as I pointed out when I first started, specifically said and specifically held that Judge Pittman, under the totality of the circumstances, his investigation was unreasonable and did not stand up to professional norms. As to prejudice, the prejudice prong, and it's not simply just limited, as the state would say, to Dr. Hutchison. Dr. Hutchison did testify that the information or evidence, expert testimony about the mental disease and the mental capacity, both as to the mental disease and defect defense and the compulsion defense, would have been extremely helpful for the jury to understand. A lot of the facts that the state pointed out here giving a false name or giving inconsistent statements to law enforcement. In fact, Dr. Hutchison directly testified to that and explained how a person with that intellectual deficiency, as Mr. Littlejohn had, she compared it to basically an 8-year-old child. And when an 8-year-old child is confronted, as Mr. Littlejohn was by law enforcement, sometimes with incorrect information, we found your DNA in the car. We've got a video of you killing the victim. Those were incorrect. That was absolutely not true. But a person in Mr. Littlejohn's position, again, if you imagine, with the intellectual ability of an 8-year-old child, when they're confronted by that, what are they going to do? What is a child going to do? They're going to respond by saying perhaps inconsistent statements or coming up with stories. The point being, that could have been explained by a mental health expert who should have been put on, and the jury should have heard that kind of evidence. That's why Dr. Hutchison said it absolutely would have been helpful. But not only Dr. Hutchison, Kevin Leffler, who actually represented Mr. Littlejohn for about a year, he absolutely said that he would have put that defense on and that it was warranted. Not only mental disease and defect, but the compulsion. He also said how helpful that would have been for a jury to analyze in this case. Kate Zigtima, she was his appellate attorney. She said the same thing. I understand her communications with Mr. Littlejohn probably were not as much as some of the other attorneys. But she nevertheless said, even in my telephone calls with him, I could tell that, you know, the communication was not getting through, or it was very difficult to get through. Everyone that had contact, Dr. Hutchison, Kate Zigtima, Mr. Leffler, all of these individuals said within a short period of time, just in interacting, they were able to tell that there was a definite intellectual problem here. And yet, you know, Judge Pittman, you know, said, well, I didn't have any problems communicating with him, and he was an intelligent young boy as far as I was concerned. Well, again, that's a factual dispute, and I would submit Judge Ward found in favor or against Judge Pittman's assertion. Again, a lot of what the state wants this court to do, you know, they have problems with Dr. Hutchison's testimony. Well, they had the chance. If they wanted to call their own mental health expert, they could have done it and said, Dr. Hutchison doesn't know what she's talking about. Here's the reason why she's wrong. They chose not to do that. Now they want this court on appeal to find problems with Dr. Hutchison and or her evaluation and reversing. Well, that's not, as I've argued, not the purview of the court to reweigh evidence. There is substantial competent evidence that supports both bases of Judge Ward's decision here. And that is Judge Pittman rendered ineffective assistance as to failing to properly and reasonably investigate the mental disease or defect defense, and also his failure to put on any of this evidence in support of his chosen defense, his chosen compulsion defense. We would submit the jury not hearing any of this evidence, which is compelling, that rendered Mr. Littlejohn's trial fundamentally unfair. And ultimately, under Strickland, that's really the final analysis. Was the deficient performance of Judge Pittman, did it render this trial fundamentally unfair? And I think the resounding answer to that must be in the affirmative. We would ask this court to affirm Judge Ward's decision, setting aside Mr. Littlejohn's convictions and granting him a new trial. But I'm certainly here if the judges have any other questions.
Apparently not. Thank you.
Thank you.
May it please the court. Just to address some of the arguments and questions that came up for opposing counsel. There was testimony from Mr. Pittman that he did discuss briefly with Dr. Fletcher the possibility. He said he didn't go into great detail with it because by that point he didn't have any reason to believe, based on what he had already done and investigated, that it was worth pursuing further. And as far as the general question about, well, shouldn't he have consulted or hired an expert, the question isn't whether he could have done so. Of course he could have done so. But clearly the case law doesn't require a defense attorney to hire an expert in every case. To get to the point where you hire an expert, presumably you will have already done a lot of great groundwork to figure out whether that's necessary. Hiring an expert isn't step one in the process. You do that when it's appropriate. Otherwise, counsel in any case is going to be wasting a significant amount of time pursuing fruitless theories. As an example, if all of the facts shows that the defendant clearly was at the scene of the crime, and maybe the defendant himself even acknowledges that, could counsel still spend significant time trying to run down an alibi defense? Sure, he or she could. Is that a beneficial use of their time when they've already determined that it simply would not be a successful defense and that there's another approach that they feel would be more successful? So I urge the court not to put too much stock in the mere fact that he didn't hire an expert and take that to mean that he didn't investigate the possibility of using this defense. He simply testified that he specifically said, I absolutely would not have been opposed to hiring an expert if I felt that it was warranted based on the facts. As far as this issue about the compulsion and mental disease and defects, it's not so much, and I don't think Judge Pittman testified that he felt that these were mutually exclusive. And he did acknowledge that he knows that the defense can run multiple defenses. His concern was simply that it wouldn't be beneficial to do so. And as I indicated in my earlier argument, while reasonable people might disagree with that and think that it might have been helpful for that evidence to come in, again, that's not enough to show that it was ineffective just because he came to a different conclusion than what the defense testimony or the defense experts testified to at the hearing. I'd also point out that to the extent that Judge Ward made a factual finding as far as Mr. Pittman's testimony about the juries generally not favoring mental disease or defect, I think when you read that ruling, it almost appears as if the court is indicating that Judge Pittman testified flat out that it's not applicable, he never feels that it's worth running, and that it simply is something that he would never consider doing. But I think the record is much more nuanced, and as I pointed out, he testified that he actually had personally used that defense before. So it wasn't a matter where he's saying categorically he thinks that it's not a defense or should never be a defense. He simply didn't think that it was usually a successful defense. And that in this particular case, especially given what he had ascertained from his review of the record and his consultation with his client, reading the reports from the medical, from the psychologist, that all bolstered his decision not to use it in this case. And then two brief things, because I'm sure I'm up against my time. One is, we're not here to determine whether the defendant is smart. We're not. Nobody is suggesting that the defendant has an extremely high IQ. But of course, being a below average IQ individual does not mean that you cannot form the intent. The mental disease and defect defense in Kansas is very limited, as your honors know. And so if the standard were that any time somebody has a below average reading or math ability that the defense has to be run, then it would be run in the vast majority of criminal cases in Kansas. Finally, I would point out, and I cited in the brief, Sprague, an unpublished opinion, because I think it's noteworthy that that opinion involved the same attorney and the same expert, Dr. Hutchinson, that we have in this case. And it also involved a claim that trial counsel was ineffective for handling, in their handling of the mental disease or defect. And I would submit that those two cases show a common theme, and that is second guessing. This is the ultimate Monday morning quarterbacking. The facts of this case were, quite frankly, brutal for the defense. They killed the defendant and his cohort, killed this man in broad daylight on a busy street in Wichita. A completely innocent victim. No rational explanation for this killing. Sometimes there are cases where there simply is no good defense, and the defense attorney is left in the position of having to do the best he or she can to present a defense for a jury. And in this case, after thoroughly examining the facts, meeting with his client, reviewing all of the relevant medical reports and psychological reports, Judge Pittman came to a strategic decision in this case. And while we can all question whether we would have done the same in that situation, the test requires much more than that from the defense. And specifically, while counsel ended his argument by saying the question is, well, was this a fair trial? The ineffective assistance test requires that they show that this fell below an objective standard of reasonableness, and that but for counsel's alleged errors, there's a reasonable probability that the result of the trial would have been different. So even if you find that counsel made a mistake or did something different than another attorney would have done, he still has a high bar to clear to get over the prejudice problem. Our position is that the record is now complete. We've had this evidentiary hearing. We know why Judge Pittman did what he did. Our request would be that you reverse this decision and reinstate the defendant's guilty conviction in this case. We don't think it's necessary to remand for any further proceedings because we've already heard from Judge Pittman. We know that he had strategic basis to do what he did. So we would ask that the court simply reinstate the conviction. As a fallback, we would assert that if there is the need for more testimony or further findings, that would be more appropriate than simply letting this decision stand and the defendant's conviction being reversed. Thank you, Your Honors.
All right, counsel, thank you very much for your briefs and your arguments. You both did a very good job. As I said, we'll take this case under advisement. We know that decision is important to a lot of people, and we'll get that out to you just as soon as we can.